Questions on notice. Request for leave to move the adjournment of the House on definite matters of urgent public importance. Statements by ministers.
The Attorney General.
Thank you, Madam Speaker. Madam Speaker, I've been authorized by the Cabinet of Trinidad and Tobago to make the following statement. Trinidad and Tobago is in the midst of one of the most aggressive and profound reformations of the criminal justice system. No other government has sought to attack the scourge of crime by improving the whole system comprising plant and machinery, people, processes, and law simultaneously. Taking decisive action on the expansion of the judiciary, the increase in the number of judges, masters, registrars, and courts, the creation of divisions of court, the introduction of rules of court, the merger of jurisdictions of the court, the hiring of hundreds of professionals across the court system, the expansion of the prosecutorial system at the Office of the DPP and the Trinidad and Tobago Police Service, the establishment of a public defender system, the protection of witnesses, the introduction of laws to remove bottlenecks in the criminal justice system, laws to fight hard and bloody crimes, and laws to follow the money and take the profit out of crime, have been driven by dedicated data capture and rigorous analysis, with a focus, Madam Speaker, on the effect to the lives and consciousness of the people of Trinidad and Tobago. Madam Speaker, in addressing the reform of the criminal justice system, many have ignored the profound effect that decriminalization of certain offences can have in the criminal justice system. The judiciary, in its publications, has demonstrated that approximately 146,000 cases come to the magistrates' court each year. Of that number, 104,000 cases are in respect of motor vehicle and road traffic matters alone. As you are aware, the government took the decision to amend the law to move road traffic offences into violations, and shortly, with the operationalization of the U-turn system of the Ministry of Works and Transport, Trinidad and Tobago will witness the removal of these road traffic matters out of the magistracy and into an electronic demerit system. Madam Speaker, the judiciary data also reveals that in the period 2007 to 2018, 84,668 cases came before the magistracy under the Dangerous Drugs Act for possession of marijuana for the purposes of trafficking, cultivation of marijuana, and the gathering of marijuana. 71,964 of these cases were for possession of marijuana alone. In the law term 2017 to 2018, the judiciary reported that 9,553 marijuana-related cases came before the magistrates' court, with 8,316 being for possession of marijuana alone in 1 year. Many of these cases relating to marijuana demonstrate that mostly poor and underprivileged men suffer the brunt of the hard side of the law, with 3,429 people having been remanded for marijuana-related offences in the period 2010 to 2018, being approximately 500 people each year unable to access bail even though granted bail by the courts. The burden to the taxpayer of hundreds of millions of dollars expended in remand incarceration is as atrocious as the effect to the lives of the accused and their families. Convictions for possession of marijuana have derailed many lives, as they stand as a bar to education, travel, and employment, just to name a few. The government, after significant research, wide stakeholder consultation, and careful legislative scrutiny, is of the firm view that it is the correct time to amend the Dangerous Drugs Act and to cause the strict licensing and regulation of the research, cultivation, supply, commercialization of marijuana through the establishment of a cannabis control authority. Whilst others have flirted or failed in the 25 years since the passage of the Dangerous Drugs Act, I am pleased, as Attorney General of this government, to therefore witness the introduction of two bills today, namely the Dangerous Drugs Amendment Bill 2019 and the Cannabis Control Bill 2019. Together, these bills will amend the Dangerous Drugs Act and birth a new regulatory regime which will move our laws from a colonial, archaic past and into the future. The Dangerous Drugs Amendment Bill 2019 seeks to define marijuana comprehensively as cannabis, to decriminalize certain quantities of cannabis and cannabis resin, to prohibit the use of the substance in public spaces, all educational institutions and places of work. It also seeks to abrogate the present strict prohibition of the administration of the substance to children in medical cases only. It also modernizes the criminal justice system by introducing a tiered penalty system premised upon the quantum of the substance in possession. Madam Speaker, under this amendment bill, a person may now lawfully grow no more than 4 cannabis male plants at his residence without a license. Under the tiered possession scheme, the bill proposes the abolition of the present regime whereby possession of any amount is an arrestable offence. This tiered possession scheme will establish lawful limits for possession and use. Hence, under the new scheme, a person found in possession of 30 grams of cannabis or less will no longer be arrested for possession. That being said, the government also proposes to impose an upper limit for lawful possession of cannabis or cannabis resin, respectively. That limit will be 60 grams as proposed by this bill, Madam Speaker. The bill proposes that possession of more than 30 grams but not more than 60 grams of cannabis, or more than 5 grams but not more than 10 grams of cannabis resin, is to now be treated by a fixed penalty ticket system, with the brunt of the law being applied only where there is a refusal to pay the fixed penalty and only after the possibility of community service as an alternative remedy is explored. The bill strictly criminalizes smoking or using cannabis resin in a public place. The bill also establishes specific penalties for the possession and trafficking of dangerous drugs such as amphetamines, ketamines, and LSD, only recently introduced as dangerous drugs under the Dangerous Drugs Act by this government. The Dangerous Drugs Act will also strictly criminalize acts involving children. Hence, for example, a person who possesses cannabis, even within the allowable limits, will be prosecuted for having the substance on a school premises, a bus, or school yard. He will be liable upon summary conviction to a fine of a maximum of $250,000 and to imprisonment for 5 years. The government is also concerned about the effect of the substance upon persons during the course of their work and operation of certain machinery. Thus, the bill proposes to prohibit persons who, whilst under the influence of cannabis, do anything which constitutes negligence, professional malpractice, or professional misconduct. A similar prohibition applies to any person who operates, navigates, or is in physical control of any motor vehicle, aircraft, ship, whilst under the influence of the substance. In both instances, the conduct attracts a summary conviction to a fine of $250,000 and to imprisonment for 5 years. It follows that in the interest of justice, persons with charges before the court for the new upper limit of 60 grams of cannabis and 10 grams of cannabis resin may apply to be discharged, and that the criminal records of persons with convictions for possession of the substance will be expunged, and that they will be able to apply for pardon under Section 87 of the Constitution. Under the Cannabis Control Bill, the other bill, a state entity, the Trinidad and Tobago Cannabis Authority, will be established to administer a licensing and registration regime to legitimize, establish accountability and transparency for the use of cannabis by persons and bodies engaged in religious, sacramental, medicinal, and commercial activities. The authority will have the power to issue 8 types of licenses, namely a cultivator license, a research and development license, a laboratory license, a processor license, a retail distributor license, an import license, an export license, and a transport license. Notably, as their names imply, the licenses represent different points, that is, from growth to that involving therapeutic use. There will be strict control for medicinal use and for religious purposes, which are separately addressed in the bill. Only certain persons will be eligible for licensing and registration, and there is a guaranteed minimum local content of 30% of ownership for companies and cooperatives so as to avoid the abuses that occurred with multinational domination in other territories. There are careful safeguards in the bill, Madam Speaker. With respect to religious organizations, there is the prescription for a requirement for registration under the Non-Profit Organizations Act 2019, as well as strict dispensary regime. Similarly, only persons licensed as a medical practitioner may lawfully dispense and administer medicinal cannabis. While cannabis growth and its use has desirous implications for the national purse and will surely be welcomed by the medical, patient, and religious communities, the government will curtail opportunities for abuse of the new licensing and registration regime. This is effected through criminalization of behavior, which adversely impacts the administration of the authority, breaches of confidentiality, unlawful disclosure of information, and undisclosed interests in businesses seeking a license and dealing with cannabis without a valid license. Furthermore, the government is mindful that while the reform allows the wider population to have greater access to, albeit limited purposes, it remains concerned that reform should account for the interests of nation's children. They must be protected from misuse of the substance. To that end, the Cannabis Control Bill 2019 protects our children by criminalizing certain activities involving children. Firstly, to all parents and guardians or caregivers of children, please note, if a child under your care suffers from a medical problem for which medical cannabis can be helpful, you are required to exercise due diligence and care. You may be criminally liable if you fail to obtain written certificate from the child's medical practitioner certifying that the child requires medicinal cannabis to remedy his ailment. Secondly, to all persons who accompany children to places of worship or similar environments, you may face the court if you cause or permit that child to use cannabis at a place of worship, a sacramental dispensary, or at an exempt event. The penalty that you may be subjected to is a fine of $250,000 and to imprisonment for a term of 5 years. Madam Speaker, these bills laid in the House of Representatives today represent the work of a progressive government dedicated in the mission of, quite simply, getting it done. The benefits to the people of Trinidad and Tobago are so obvious now that the work has been done and put into context. It is axiomatic that the criminal justice system should focus on serious crime and that all roadblocks to justice should be immediately removed so that judicial and law enforcement time can concentrate where it matters most. It is equally axiomatic that Trinidad and Tobago should be anxiously conscious of the developments across the world, and those developments, of course, informing us that there is a recognition of the economic potential of cannabis production once unshackled from the mid-19th century colonial values. Whilst others have slumbered, Madam Speaker, we have toiled. We shall get it done. I thank you, Madam Speaker.
Member for Orupuchis.
Thank you very much, Madam Speaker. Madam Speaker, to the honourable member, pursuant to 24.4, member, could you indicate, given your statement, that there are clearly some complex issues and provisions and new institutions to be established to bring this regime into force, given that the opposition leader and members of the opposition, in particular, I think Sama Barataria, has already pronounced, could you indicate, with no pun intended at all, whether these measures will go to a joint select committee?
Madam Speaker, it was without mistake that I referred in the statement to whilst others slept that we have toiled. The newfound love by the leader of the opposition for this decriminalization and commercialization, perhaps not as new as one may think, betrays the fact that for a full 5 years and 3 months, the leader of the opposition, as Prime Minister and Senior Counsel with the capacity to amend law, did absolutely nothing for the benefit of the people of this country. In having created this bill and that to develop the Cannabis Authority Bill, we intend to take this to the floor of the Parliament, Madam Speaker. We intend to have the debate ensue like any good government would. We must listen to the concerns that come out on a fairly complex issue. That is the reason why it has taken us, and in the AG's office in particular, some time to perfect the work product now before us. We welcome the newfound enthusiasm of those opposite to the reform of law. We will simply get it done. Thank you, Madam Speaker.
Introduction of bills. The Insurance Amendment Bill 2019 in the name of the Minister of Finance.
Honourable members, the question is that a bill entitled An Act to Amend the Kabir Association of Trinidad Incorporation Ordinance 1932 be read a first time. All in favour say aye. Aye. Any against? The ayes have it. Clerk.
A bill entitled An Act to Amend the Kabir Association of Trinidad Incorporation Ordinance 1932, the Cannabis Control Bill 2019 in the name of the Attorney General, the Dangerous Drugs Amendment Bill 2019 in the name of the Attorney General. Public business, private members' business, motions.
Member for Caroni Central.